Yes.
My Lords, could we have a quick look at 3104 at Al Jeddah, decision of the Court of Appeal, because again this, it seems to us, would be a cautionary note in extending the Act of State doctrine into an overarching doctrine in the way Lord Sumption favoured. This was an Iraq internment case. It starts at 3104. I just wanted to take you to the treatment of what was called the justiciability issue at 3126. Issue 2 in the judgment of Lady Justice Arden. The judge held there was no conceptual difficulty about applying the law of Iraq, and it made no difference in principle that the relevant provisions were in the Constitution. He distinguished the earlier authorities had been cited. Mr. Swift submitted the judge erred in finding Mr. Al Jeddah's claim that his detention was incompatible with the Constitution was justiciable in an English court. Lady Justice Arden sets out the submissions. She notes at 73 that Mr. Hermer sought to uphold the judgment of the judge, and he referred to a case which we've referred to, the Talina, an Estonian state steamship line, which seems clearly a case of the courts being prepared to look at the validity of foreign sovereign decrees, and she resolved the issue at 74 in favour of not casting the preclusionary blanket on that part of the case. In my judgment, the judge was right. The provisions of the Constitution with which this appeal is concerned clearly provide judicial and manageable standards. English courts are familiar with Constitution interpretation. The issues in this action do not involve a challenge to the validity of the Constitution of Iraq. The court would only be reaching conclusions as to the meaning of the Iraqi Constitution for the purpose of this private law claim in damages. And so that we suggest is a recent example. I should say that there's similar passages in Lord Justice Elias at paragraphs 184 to 189, pages 3149 to 3150. And he concludes the legal issues arising under Iraq law need to be resolved in order to decide a dispute which is properly before the courts. And obviously there's no argument in this case but that this dispute is properly before these courts, and we say that all the questions of Venezuelan law need to be resolved in order to deal with it. So it's on all fours with that.
But that was interpretation.
Yes?
It was interpretation in Al Jeddah.
Yes, it was. And some of our points are points of interpretation.
Thank you.
Your Lordships are being urged to prefer the minority view of Lord Sumption in Belhaj. It would be tempting to spend a lot of time, in fact, I ought, in a way, to spend a lot of time looking at what the majority said, but I'm sure your Lordships are familiar with it. I simply make the point that we shouldn't be diverted from the fact that this was a minority judgment with which only one other member of the court agreed. Can I summarise why we say you should prefer the much more cautious view of the majority and reject the reading of Lord Sumption? First of all, we suggest there is, at the very least, an over-reliance on the Duke of Brunswick case, which is very slender authority, we would suggest, particularly given the time when it was made, and which we would suggest, if it supports anything, supports Rule 3. We would suggest there's a misreading, or at any rate an over-reading, of the Princess Olga Paley case, and your Lordships have my submissions on that. We say, thirdly, it conflates acts of a sovereign with acts of state. And it therefore does not properly take into account the insight of Lord Mance. And we have, I think, also referred you to Lord Mance writing extrajudicially on this topic, and there's a very helpful article which we've referenced from Lord Mance.
Do you have the reference to hand?
No.
Right.
I'm sorry. We'll find it very quickly. But it's in our case, but I'll find it. But we would suggest that the Lord Sumption's approach applies in a sense an absolutist approach, which is not in keeping with the trend of modern jurisprudence, nor indeed modern state practice. And if it has any real foundation, has it in the days of absolute monarchies. And we would suggest, and here I hesitate to stray into areas about which I'm sure one member of the court has forgotten more than I know, which is the question of sovereign immunity. But just as the absolutism of the old law of sovereign immunity waned, relaxed, and was put into the Sovereign Immunity Act with a non-absolute approach to sovereign immunity, so it seems to us that it would be, examples being, the ability to sue in relation to state assets, albeit, note in parentheses, not the assets of a state bank. But just as that absolutist approach, which would have been undoubtedly the attitude of the courts when the Duke of Brunswick case was decided, that has moderated over time, so surely this cannot be the right time to extend the Act of State doctrine in an absolutist way. And finally, of course, we make the submission that the Sumption absolutist approach does lead to profound tensions which would lead to results that are contrary to the rule of law. Now, on that last point, can I deal with the point raised in argument that the answer to our Miller 1 and 2 putting up the mirror point, the answer to the point about domestic unlawfulness can be found in the public policy exception? That, in our submission, is a bad point for the following reasons. The public policy exception is narrowly drawn, and it provides that if the act in question, the act over which the blanket is sought to be thrown, is one which is so repugnant to British public policy, then you cannot cast the preclusionary blanket over it. And it is, in our understanding, the act itself which is sought to be sued on, which must be of the right nature to engage the exception. Now, if one were to use the public policy exception in order to get over the fact that the STJ had declared these acts to be unlawful, one would be using a public policy exception in a totally different way. Because we accept, and the Guaidó board say we're right to accept, that we cannot bring a public policy exception on the facts of the present case because there is nothing contrary to English public policy in the particular appointment of one person rather than another to the board of the BCV. Just as there's nothing contrary to public policy in the nature of the Maduro appointees to the board of the BCV. We are miles away from the public policy exception. We've always accepted that, which is why we don't rely on it. So unless you were to radically redraw and reposition the public policy exception, it cannot provide an answer in this case. And there would be many cases where a public policy exception could not provide an answer. So if we go back to the American Supreme Court saying something's unconstitutional, it might very well do that for reasons which are uniquely American, arising out of the United States Constitution, a matter on which there might be no public policy position in this jurisdiction. but one would still be faced with the paradox of it being said that one should give effect to a foreign act which had been declared unconstitutional by the local courts. So, in other words, either the public policy exception as currently drawn is inadequate, or you would have to create a totally new and different type of exception to deal with it. I think that's what it boils down to. But one certainly cannot pray in aid the presently formulated public policy exception, and that's why we haven't sought to rely on it. So perhaps it is worth pausing to think what solutions there might be to the problem which so much troubled the Court of Appeal, this problem about the position where there is a foreign court which has pronounced on the issue. If you decide not generally to extend the Act of State doctrine, the point won't really arise because other exclusions will be operative in this case and there will be no Act of State preclusion. That would be a duck, and perhaps for that reason not terribly attractive. An alternative solution which would deal with, certainly with this case, would be to treat rules 1 and 2 simply as conflict of law rules, as Lord Mance and the majority were minded to do. Follow that part of the Carl-Zeiss ratio, I think, which I took you to earlier, the reference is 2414, and simply say that a domestic determination of unlawfulness would be determinative and effective. Would be another possible solution. A third possible solution, and the one to which my, I think, second submission was directed, would be to endorse Lord Mance's approach to what is an act of state, to say one must look at the foreign constitutional arrangements as a whole before deciding there's anything which engages, and provide that the Act of State doctrine is engaged only where the act is properly to be treated as an act of state, and say that an act which has been declared unlawful by the appropriate domestic courts, and or, we would suggest, which is in fact unlawful by its domestic law, is simply not to be treated as an act of state. Fourthly, you could do that, but graft onto it a carefully constructed exception to deal with the position where the foreign court was in some sense a bad court. They make the prima facie rule that foreign declarations of unlawfulness were to be treated as binding, in effect, and graft onto that an exception. It's then going to be an exception.
It doesn't need to be created an exception because there's already a doctrine that the act of a foreign judgment won't be recognised if it's the product of a biased or perverse court.
Yes. Yes. No. I see what you mean. So adopt the same approach as is taken to recognition.
And you wouldn't need a rule that the foreign judgment would be binding. It would be enough that the court could take account of it.
Well, you're asking us to recognise the judgment, basically.
Yes. Yeah.
Recognition can arise in any context. It doesn't have to be a formal process. If you plead the judgment in your defence, you're relying on the judgment. But if it won't be recognised because it's been a failure of substantial justice, to use the term in UKOS, then the English court won't recognise its effectiveness.
But I think one has, with respect, to be quite careful here, and this is yet another problem of trying to deal with this before any facts have been found. Suppose you had a case in which the foreign domestic court had ruled that a particular act was unlawful. And suppose that it were possible to show that it was not an independent and impartial tribunal, it was a bent court that reached that decision. But suppose it was equally obvious that the result was correct, and that a non-bent foreign court would have reached the decision. Not easy to see what the right result is in those circumstances, because in a sense, if you say, okay, completely irrelevant then what the foreign court said, you're putting it in our case, President Guaidó is better off because there's a bent foreign court. And that does seem slightly counterintuitive as a result. So,
well, he's better off if the act of state doctrine means that we won't decide for ourselves questions of foreign validity of the act.
yeah.
But he's not then made worse off but by the foreign judgment if it doesn't carry any force. That would have to be concluded at a hearing.
Oh, that will obviously have to be concluded at a hearing. But all I'm saying, I think, is that there's potentially a danger of throwing the baby out with the bathwater. So that if it were the case that the judgment was not one which would, in the ordinary way, in different contexts, be treated as enforceable, it might be that what it said was nevertheless right. And when one is crafting an extension stroke restriction of the act of state doctrine, it seems to us that is, at the very least, a possibility which that extension or exception needs to deal with.
One way of looking at it might be to say, I'm looking at the moment at Buck and the Attorney General, and the principle stated there by Lord Justice Diplock is that for the English court to pronounce upon the validity of a law of a foreign sovereign state would be to assert jurisdiction over the internal affairs of that state. That would be a breach of the rules of comity. And therefore, you don't do that. But the argument would run that there's a difference in principle between doing that, on the one hand, and giving effect to a judgment of the court of the foreign state itself, which impugns the validity of one of its own laws.
No, I completely agree. But in a sense, moving on from that, suppose there is that position, the foreign court has given its judgment, but there is something wrong with the foreign court. Judges take bribes, for instance, let's just say. Now, it does not follow from the fact that on occasion the judges of a court take bribes, that everything that court says about the law is wrong. And so it does seem to us that if you are crafting an exception or extension, and particularly in the absence of any facts having been found in this case, that is at least a possibility which that crafting of the law needs to deal with. And it's not.
Well, the non-recognition of the foreign judgment can either go to the particular case because of circumstances that made that particular judgment not independent, or it can be a systemic argument that the courts of that country are not courts of law as we would recognise them.
Exactly.
In the way they operate.
Exactly. And suppose it were a systemic attack, but that the court here, having looked at the judgment of the foreign court and its treatment of the constitutional issues, looked at it and thought, well, that makes eminently good sense. It may have come from an unreliable court, but it is a judgment of a foreign court. It makes eminently good sense.
Well, that just goes to the question of whether we take on the task of deciding questions of foreign law or we don't.
Yeah.
You can't cannot sit in judgment of the rectitude of the foreign court's particular judgment. If a foreign court is systemically unrecognisable, then we can't give marks out of 10 to a particular judgment of that court.
Yeah.
That would be interfering in the internal affairs of the foreign state.
But in that case, I'm suggesting the court must then decide for itself.
But that's what Lord Justice Strickland, at any rate, told us we couldn't do.
Yeah.
Well, that then produces, does it not, a somewhat paradoxical situation? In the case of the person subject to the foreign court's jurisdiction who is acting contrary to the law. Because that person is better off. His acts here are going to be given effect to but only because the domestic court's rulings are regarded by the courts here as not enforceable.
Yeah, but your premise rather begs the question. I mean, the premise is he's acting contrary to the law, and the only way this court can ascertain that he's can be satisfied that he's acting contrary to the law is by virtue of a foreign judgment to that effect.
Well, with respect, Al-Jeddah doesn't take that view. The Tallinn case doesn't take that view.
Well,
that's the first issue, isn't it?
Yeah.
Mr. Vinyl, on your approach 3 or 4, would it be open to a court in this jurisdiction to give effect, to recognise, a judgment of the Senior Tribunal of Justice, which declared that Mr. Guaidó was not the president?
That raises the issue on which we were refused permission to appeal. So the answer, which I cheekily put in a footnote anyway, was it would not preclude, but since I was refused permission to appeal on that point, I was refused permission to appeal on the point.
Thank you.
So that's essentially what I wanted to say on the issue which was dealt with by the Court of Appeal on Act of State, in our case. So I want to move on to the other points in our contingent cross-appeal, which I will take shortly. The first is, let me just find the right document. What we have numbered as our submission number 4, it starts at paragraph 193 of our note, electronic 2.1.
Sorry, page please.
Yes, I've written down a reference which plainly isn't right. Ah, that is what I've written down. I'm grateful. And I was looking at the Guaidó board case, which is why I didn't find it. So this is the territoriality point. The competing contentions here are, we say, that the Act of State preclusionary rule is limited to acts, the direct consequence of which is felt only in the foreign state. For instance, the classic example of expropriation of property in and by the foreign state. And the Guaidó board says, well, the acts in question are so entirely Venezuelan and have so little impact on anything anywhere else that the Act of State preclusionary rule does indeed apply to them. Now we accept, indeed we say positively, and on both parties' cases there are tensions here in terms of analysing where an event takes place and where it may have relevant consequences. We say positively that the appointments of the Special Attorney General and of the board members that are in issue here are appointments intended to take effect, if they take any effect anywhere, in Venezuela, and that they are Venezuelan acts, and that's why their legality and effectiveness is to be determined under Venezuelan law, just the same as the Maduro board's appointments would be. And we also agree with the Guaidó board that their purported impact was not limited to the UK, just like the Maduro board appointments. Their impact would be anywhere, because the wording used is appointed to the Venezuelan board, not as a general board member, but in a sense as a board member with special responsibility for Venezuelan assets abroad. That's the curiosity, in a way, of the appointments. The BCV otherwise is left with its normal appointees to run the business of the bank. Guaidó board are not appointed to run the BCV. They're appointed for this unique role in relation to Venezuelan assets abroad. So the Guaidó board's position is the court here cannot consider our challenges because of the preclusionary rule. And so we perhaps have to ask how or why there is a territorial limitation on the act of state law. And it seems to us that it is essentially a question of sticking your nose in where you have no right to put it. But it equally seems to us that if that is the rationale behind the territoriality limitation, it's rather difficult to see why it should apply in our case. Because indeed the effect, although these are Venezuelan appointments, the whole motivation of Mr. Guaidó is to have some effect on something that happens in Threadneedle Street.
I know you dispute the interpretation of Princess Paleolga, but there the property was in England, wasn't it? And the question, though, was the title the title to it, which depended on what had happened in Russia. And one might say, by analogy, the property that the Guaidó board wants to put its hands on is sitting here, but the authority to bring it in depends on validity of acts in Venezuela.
Yeah. Well, that's right. The territoriality exclusion, as it's put in relation to property, depends on where the property was when the relevant expropriation took place. And so that seems to be a point of distinction. You get the argument here because, in the Princess Paley case, in all the expropriation cases, because by the time the issue arises, the property is no longer in the place where the expropriation occurred. But that's because property can move from place to place. So the territoriality point, territoriality restriction in relation to property seems a sensible one. That we can quite see. But the question is, how should it operate in this case? And it seems to us difficult to see that there's a good policy reason for a similar rationale applying in this case. We set out in our case at 200 what Professor Mann, this is 2123, he characterises it, it's clear in English law, the doctrine of the act of state. And that it's always important to remember that means that the preclusionary blanket cast by the act of state doctrine is limited to action taken by a foreign state with its own territory, or perhaps one should say, in respect of property situate in its territory. And that seems to be focusing on where the impact is felt. And so we say, if you transfer that thinking to our case, the whole, in one sense, the whole point of it is to have impact here. And therefore it would be particularly unattractive in this case to throw the preclusionary blanket. That's our point 4. Our point 5 is the point not about territoriality restrictions, but the nature of the Foreign Executive Act to which the exclusionary rule can apply. And our submission is that if there is a second rule at all, it does not apply here because the relevant acts are appointments to a board, and the second rule, as identified in Belhaj, applies only to executive acts affecting property, and that's certainly how it's put by the majority in Belhaj. The Guaidó board cannot find an example of act of state preclusion being applied to an act of sovereign appointment since 1848. They give two examples. One is Dobry and Napier from 1836, Hearing Bundle 3327. But we say, when you look at that case, the issue was not whether there was... So he was an admiral working for the Queen of Portugal. The issue was not whether there was an act of state preclusion preventing challenge to the Portuguese lawfulness of appointment of Napier by the Queen of Portugal. Rather, we say, and I'm reading from para 212 of our case on 2126, rather the question was whether domestic, that is to say British unlawfulness of the appointment, was relevant at all. And the court held that it was not. The second example that they rely on is Duke of Brunswick. I've said, I think, what I need to say about Duke of Brunswick, but we would suggest that that's not a Rule 2, a Rule 1 or 2 case anyway. I've shown you Banco Bilbao and Bank of Egypt, and Mahmoud and Braish itself is a very recent example of the Court at First Instance and the Court of Appeal being prepared to enter into an analysis of the effectiveness and lawfulness of an appointment. And if the Guaidó board are right in their purported extension of the Act of State doctrine, Mahmoud and Braish should not have been going into that territory at all. And their only answer to that, given by Mr. Otley, is, well, maybe it was thought wasn't worth taking the point. But that's not a terribly good answer, because the court itself simply should not have been engaging on those inquiries. But it obviously didn't occur to the court either to not to engage on those issues. So it seems to us that if the rule were to be extended, there would be a lot of cases taken in the wake of that, where the courts have wrongly, as it turns out, considered the lawfulness by their domestic law of appointments. Well, point 6 is the question of whether it's a Rule 1 question about the transition statute, and the question is whether the Maduro board can challenge the transition statute and acts purportedly done under it on the basis that the transition statute is not a part of the law of Venezuela at all. And as your lordships know, the transition statute is not just about appointments to the BCV. It is an attempt by the Guaidó interest to rewrite the constitution in many ways. So it's quite an ambitious and profound purported bit of legislation. Now, whether our submission that it's void and of no effect, as the courts in Venezuela have said. Whether that submission is right or not is obviously not for today. The question is whether there are issues which I can advance. And the answer given by the Guaidó board, and which found favour with Mr. Justice Tier, was the act of state doctrine prevents you from asking whether the transition statute is part of the law of Venezuela. And that, it seems to us, is an entirely circular argument. It cannot be right as a matter of logic. Because the party relying on the act of state doctrine must, as we, I think, established earlier, first of all, identify the act of state. It can't be enough to say, I contend that there's an act of state, and therefore you can't look into it. Somebody somewhere is going to have to decide whether there's an act of state, and that inquiry cannot logically be precluded by assuming its outcome. And that is what I think has been called the existential point, and was put in those terms, I think, by Lord Justice Rick. So
I still can't see how we ever get to this issue. Either we have to treat the appointments as valid, in which case that's the end of it, or we determine the legality of the appointments, in which case there'd have to be a hearing looking into Venezuelan law.
Yes, but suppose there is a hearing looking into Venezuelan law about the law of the appointments, the Guaidó board would still want to say you can't look into the legality of the transition statute.
Well, I don't see how that would still be available if they hadn't succeeded on the act's appointment under Venezuelan law in the first place.
Do you mean succeeded in showing they're lawful?
No, succeeded in showing that the lawfulness is not something we should look at.
Irrelevant.
We have to treat them as valid.
Well, I suppose because they might succeed. I mean, in the present formulation of the Act of State doctrine has two separate rules. Rule 2 and Rule 1. And remember that to trigger Act of State, they say, it is sufficient that it is an act of the head of state to trigger the Act of State preclusion. But they don't say that lawfulness and effectiveness depends only on Guaidó being head of state. They accept that they can only succeed if the power is given by the transition statute. And that's why, even if they're right on Act of State preclusion, they still need to demonstrate where that power comes from. The point we would say is, perhaps harking back to the early bit of the case, but recognition by HMG cannot of itself confer power, cannot confer authority. And particularly in a case where it is not said by the Guaidó board that merely the fact that I am head of state gives me power to appoint. They do say merely that I'm head of state allows me to throw the preclusionary blanket, but they don't say gives me power to appoint, and they have to show more than that. It seems to us that the point might arise. Lord Mance's article on justiciability is at hearing bundle 5996. And the side notes in the version of the Constitution we have are not in the authentic Constitution published in the official Gazette in Spanish. They have been, I think, added in when it was translated. So, if there's any dispute about that, we can, I'm sure, sort it out between us, but those are my instructions. So, my Lords, I just want to make the point that I am 20 minutes early in sitting down and not 10 minutes late on our agreed amendments to the timetable.
Yes. Thank you very much, Mr. Vinal.
We won't mention the 20 minutes devoted to the irrationality arguments, my Lord. My Lord, very briefly, if I may, I would like to address a number of points of fact for the sake of the record, not because I'm afraid they're analytically terribly relevant. I'd then like to address what we submit to be, with respect, some of the ongoing misconceptions in the Maduro Board's case, and to say a very little about the first four of Mr. Vinal's key submissions as he summarised them yesterday, leaving the fifth, relating to foreign acts of state, to Mr. Fulton to say something more about. So points of fact first, if I may, my Lords. Sir Geoffrey yesterday made a number of assertions as to the Maduro Board's plans for the assets in issue in these proceedings. Those plans are the subject of contested evidence below, with the Bank of England making it clear that the United Nations has finalised no arrangements with any purported Maduro Board appointees, and other material showing that a range of issues and areas of concern, including conditions relating to conformity with United Nations principles relating to humanity, independence and impartiality, control of the monies and sanctions, would need to be considered. Similarly, as to the submissions made about transparency and accountability on the part of the Guaidó Board, the Guaidó Board is subject to the scrutiny and published reporting of the still extant National Assembly under Mr. Guaidó, the National Assembly recognised by Her Majesty's government. And finally, again, evidence below shows that other assets successfully recovered by the Guaidó Board in the United States have since been used to make payments to Venezuelan health workers in Venezuela and to make payments to the International Red Cross working in Venezuela. Now, as I say, my Lords, simply to record the fact that there is no common ground on these issues, for the sake of the record. Turning then more substantially, if I may, to the what we respectfully submit to be the ongoing misconceptions. We say the Maduro Board continues to focus on what is analytically the wrong question by insisting on asking who is effectively exercising which powers in Venezuela and who is in de facto or effective control in Venezuela and who is the head of an effective government. The material question we respectfully submit is instead who is to be regarded as the president of Venezuela and who is to be regarded as vested with the legal powers of the president. And that is because it is via presidential appointments, and I emphasise presidential, that each of the Guaidó Board and the Maduro Board claim their status. That is reflected in the Statement of Facts and Issues at 4 to 7, page 1976. It's reflected in Mr. Justice Tear's judgment at paragraphs 5, 7 and 36. It's reflected in the Court of Appeal's judgment at paragraph 3. It is reflected in the Maduro Board's own pleaded case at paragraph 34.6 of its Statement of Claim. Questions of effective control or exercise of powers within Venezuela might be relevant if the court was engaged in a Somalia Woodhouse-type identification inquiry, where Her Majesty's government had made no statement of recognition. But it is, of course, we submit, not engaged in such an exercise. Her Majesty's government has spoken, so triggering the one voice principle, and that, we say, is that. If it mattered, which we say it doesn't, but if it mattered, the court would have to treat Mr. Guaidó as both head of state and head of the national executive. The term of head of government is not, in fact, one reflected in Article 226 of the Venezuelan Constitution at all. The term of president is, and he is said to be the head of state and the head of the national executive. And once Her Majesty's government has said who the president is, and once the common ground as to the wording of the Constitution is acknowledged, that result would inevitably follow. Mr. Guaidó is the...
Mr. Otti, but you seem to have abandoned, before Mr. Justice Tier, the claim that he'd been recognised as head of government and only got a holding that he was recognised as head of state and not head of government.
Well, my Lord, yes, we didn't abandon anything, my Lords, and we put the references in our printed case,
right,
which make that absolutely clear. The amendments to the pleading which Mr. Vinal has pointed to simply reflected where Mr. Justice Tier's judgment had ended up as to what was the material question.
Right.
Now, if it be necessary, but we don't submit it is because of the proper analysis as to what is material, we would invite this court to go further than the declaration of Mr. Justice Tier and declare that Mr. Guaidó is recognised as head of state and head of the national executive. But there's nothing in the abandonment point at all, my Lord.
Thank you.
Mr. Guaidó is the president. He's been recognised as such, and as I say, Article 226 of the Venezuelan Constitution then has the consequence I've just indicated. As Sir James put it yesterday, again, we respectfully submit entirely clearly, it matters not whether it's head of state or head of government. The critical question here is presidency. The answer has been given as to presidency, and properly construed, the answer given as to presidency was an answer to both questions posed by Mr. Justice Knowles. The reference, if it helps, is pages 92 to 93 of the transcript yesterday in Sir James's submissions. On analysis, we submit what Mr. Vinal's approach comes down to is to contend that Her Majesty's government could never, for the purposes of the one voice doctrine, could never recognise Mr. Guaidó while the Maduro regime continued to wield power in Venezuela. And so he is in substance contending that the one voice principle has no effect at all because effective recognition can only ever occur when it coincides with de facto control. So he replaces the one voice principle essentially with a tanks on the ground principle. That would be, we respectfully submit, to overturn almost 200 years of jurisprudence by a sidewind, and it should not be permitted, even disregarding the fact that it's not among the issues upon which the Maduro board has any form of permission to cross-appeal. Mr. Vinal also asserted yesterday that Mr. Guaidó is claiming no more than that he ought to be president and that he has exercised no powers. That is wrong. Mr. Guaidó asserted that he was indeed the president as of the 15th of January 2019, as the Court of Appeal records at paragraph 19 of its judgment, just as Her Majesty's government recognised that he was so with effect from the 4th of February. And Mr. Guaidó has exercised the powers of appointment as president, which this case, of course, is concerned with, by his issue of decree at the Federal Legislative Palace. See Mr. Justice Tier's judgment at 16 to 17, the statement of facts and issues at 27 and 29. The decree itself, in case the court wants to look at it, at 875 to 878. He has also done so within the framework of Article 233 of the Constitution, pursuant to the Transition Statute, which again, as Mr. Justice Tier held, was issued and signed by the officers of the National Assembly, again bearing the seal of the interim president. Now, of course, the validity and effectiveness of all of that is the issue before the court, but it's not the conduct of someone who simply has an aspiration one day to be president. It is the conduct of someone purporting to be president and to exercise his powers as president. Similarly, Mr. Vinell asserted that Her Majesty's government's language is all about who ought to be president, or who it would like to be president, rather than who it recognises as president. Again, we respectfully submit that is not a fair characterisation of anything in the February 2019, March 2020 or June 2021 statements in the Foreign Secretary's printed case. Turning then to the four key submissions that I want to address. The first key submission was that Her Majesty's government's recognition is properly characterised as recognition in the Lutheran Segor de jure sense. We submit there was never any adequate foundation for that argument for the reasons I sought to identify on the first day of this hearing. The Lutheran Segor sense of de jure is not an established concept. It is not used by Her Majesty's government generally. It is not used in these recognition statements, and it is only really advanced by reference to extrinsic material and an impermissible attempt to investigate the origins or policy lying behind the statement, ruled out by the House of Lords and Court of Appeal authorities that we looked at. It's now, of course, explicitly ruled out by the Foreign Secretary's printed case before this court, as we understand Lord Hodges' observations to indicate. The Secretary of State has made it clear that it was wrong for the Maduro board to adopt the Lutheran Segor sense. So it's off the table on any view, we respectfully submit. The second key submission was that Her Majesty's government had given its recognition solely directed to the international claim and limited to the position as head of state, so leaving it open to the Maduro board to contend that the court could find as a fact that Mr. Maduro was president. Again, we submit that is not what the language used said. It refers to his status as president and head of state without distinction and interchangeably, and was wider than the international claim. See paragraphs 2, 3, 33, 35, 37 to 41, and Sir James yesterday at pages 92 to 93. The terms president and head of state were also, of course, used interchangeably by the courts below. There was simply no meaningful distinction given by anyone, and there remains none. As I've submitted already, if you are president, you are by definition head of state and head of the national executive. The third key submission, my lords, was one which touches on an area I didn't address orally at all on the first day of the hearing. And the submission of Mr. Vinell was that for the purposes of issue 2, what matters is who has control on the ground, by reference to Mr. Justice Clausen and Lord Justice Clausen's decisions. Now this, we say, misstates the Court of Appeal's approach to this issue, paragraphs 85 and 88, and it misstates issue 2 as reflected in the Statement of Fact and Issues at page 1991. Each was dealing with a hypothesis where there was both a de jure recognised president and a de facto recognised president. Of course, in those earlier cases, it was a de facto recognised government and a de jure recognised government. So two competing but recognised entities. Now that hypothesis simply doesn't arise on the facts of this case now by virtue of what's put beyond any doubt in the Foreign Secretary's case and what we submit to be the right conclusion on the recognition issue. In any event, as I did submit in a different context on day one, the 1930s cases should not be followed and should be confined, and certainly should not provide the springboard that Mr. Vinell seeks. I gave references to the criticisms of Lord McNair and Sir Arthur Watts and Professor Mann. I'll add Professor Hirsch Lauterpacht to that, if I may, tab 284, page 5854, in which he was equally strident in his criticism of those decisions. the misconception as to the reasoning in Luther and Sagor which underpinned them, and the unusual circumstances which gave rise to them. Now, this third key submission of Mr. Vinell's also links to what we submit to be one of a number of contentious points in the two-page note he handed to the court yesterday. He asserts in that document that it is somehow left open whether there has been an implied recognition of Mr. Maduro as president and head of government, as president qua head of government, I'm sorry, and that even if there was no such recognition, then the court must now decide whether Mr. Maduro is in fact president qua head of government. Neither point, we say, is open to the Maduro board, and we invite the court's judgment to make that explicit in the light of the argument that's been presented. Her Majesty's government has been entirely clear. As paragraph 36 of the printed case says, it is clear that one president and one president only is recognised. Her Majesty's government has been explicit that it does not recognise Mr. Maduro de facto or de jure, and whatever power Mr. Maduro is exercising, Her Majesty's government has stated its intention not to treat him as having any constitutional authority or competence, paragraphs 41 and 45. To contend that it is still open to the Maduro board to invite the commercial court to embark upon an exercise of identification of Mr. Maduro as president is a more extreme version of the course of conduct ruled out by both Mr. Justice Hobhouse and Mr. Justice Mance in the two decisions we looked at. It would inevitably run directly counter to the one voice principle. And then the fourth key submission that Mr. Vinell advanced on the issue of recognition was to contend that Mr. Guaidó does not in fact have power domestically to appoint an effective ad hoc board, because no such act by him can be effective, was how it was put. Now that is, with respect, entirely circular. Mr. Guaidó is recognised as the president. He has purported to act as president in appointing the ad hoc board. His appointees have accepted their appointments. If those appointments are treated by this court as valid and effective, then they will be. My Lords, before handing over to Mr. Fulton, and just on one point, because it crosses over perhaps between recognition and foreign act of state, if I could just respond to the question my Lord Jones put to Mr. Vinell as to whether recognition and one voice would require this court, if we're right so far into the argument, or the courts below, to ignore an STJ ruling which proceeded on the basis of or found that Mr. Guaidó was not the president, or found that Mr. Maduro was the president. We do submit that is precisely the course which would follow, and it's the only course which would be consistent with the one voice doctrine. And it may be, and I'll leave this to Mr. Fulton, it may be that at least illustrates one context in which it is appropriate and proper for the courts of this jurisdiction not to consider itself bound by a pronouncement of a foreign court, even without any allegations of corruption or wrongdoing against that court having been levelled. My Lord, unless there's anything further, I'd like to hand over to Mr. Fulton, if I may.
Thank you very much indeed, Mr. Martin. Yes, Mr. Fulton.
My Lord Reid was absolutely right that the constitutional crisis afflicting Venezuela infects all organs of the state. In relation to the TSJ, I'd direct your lordships yesterday to page 224. And your lordships see there at paragraph 1.3 and C to D, allegations are made as to decisions by the TSJ, both to assume all legislative powers of the National Assembly and then to delegate legislative powers to Mr. Maduro, allowing him to reform laws and codes at his discretion. And so our pleaded case is that there has been a total collapse of the separation of powers involving the TSJ. Mr. Maduro's next strategy was to establish a rival legislative assembly, and that's called the National Constituent Assembly, and you'll also see reference to that in the agreed chronology at 6417. I beg your pardon, 6418. In the entry at May 2017, a National Constituent Assembly is established under Article 347. And then 2 entries further on over the page, the following month, the TSJ issues a judgment declaring that there is no constitutional limitation on the National Constituent Assembly. And so again, highly problematic collapse of the separation of powers in terms of the judiciary and the legislative structures. And then, as Mr. Vinal showed you, this is at page 6419, in the entry at May 2018, first of all, the election was held, and Mr. Maduro claimed victory, and then in the following month, the TSJ issues a judgment ruling that Mr. Maduro is the legitimate president of Venezuela. And so the TSJ is implicated in all of these steps, rulings being put out very quickly after the steps which Mr. Maduro is taking to attack the democratic structures and the rule of law within Venezuela. And no doubt these extraordinary steps taken by the TSJ are part of the reason why Her Majesty's government has considered it appropriate to place both the president of the TSJ and the vice president on the UK sanctions list. The court will see that at page 1248. Entry number 25, in the second line on the right-hand side, Your Lordship see reference to the position of Mr. Perez as being President of the Supreme Court of Justice, the reasons for the sanctions imposed upon him, that as President and former Vice President of the Supreme Court of Venezuela, in these roles he has supported and facilitated the government's actions and policies which have undermined democracy and the rule of law in Venezuela, and is responsible for actions and statements that have usurped the authority of the National Assembly, the National Assembly being the lawful constitutional legislative body. To similar effect, 2 entries further up at 23 are the sanctions imposed upon the Vice President. Mr. Mendoza Yova has been involved in repeatedly undermining democracy and the rule of law in Venezuela. The TSJ deprived the legitimate governing body, the National Assembly, of its constitutional powers through several rulings, including through nullifying decisions of the National Assembly Board, nullifying the Democratic Transition Act, that's what we've been referring to as the transition statute, and stripping immunity from members of Parliament. And so that, in our submission, makes Mr. Vinal's contention that this is all analogous to a US Supreme Court situation rather difficult. None of the judges of the US Supreme Court are subject to UK sanctions for an assault on the rule of law. They don't behave in the manner just described in the agreed chronology. And crucially, as Mr. Otti just briefly alluded to, there isn't an outright conflict between who the US Supreme Court and HMG regard as the president of that country, whereas that's the position which this country is faced with, where the TSJ has declared Mr. Maduro to be the president and continued to strike down the attempts being made by Mr. Guaidó and criticizing Mr. Guaidó and his associates for their usurpation of power. Your Lordships will remember that from Mr. Justice Tear's judgment. And so in those circumstances, the the analogy with the US position just couldn't be more inappropriate. And I'm not here previewing the argument as to all of the many reasons why the STJ decisions shouldn't be recognized if it became relevant to get into that debate. I make these points instead to show why the foundational premise for Lord Mance's observations don't arise here. Responding to my Lord Reed's point, Lord Mance was envisaging a situation where the foreign state is operating normally. There wasn't a breakdown of law and order, there wasn't a constitutional crisis. It was...
I don't see how you could make this argument without any findings of facts to make it on.
Well, my Lord,
you could point us to all this material, and it may be overwhelming when there comes to be a hearing about it, but at the moment we're deciding preliminary issues in which we have to put all this aside, don't we?
My Lord, as I say, I don't rely upon it in order to persuade your lordships not to recognise the TSJ decisions, although all of this material would be in play in that context also. I raise it because these are agreed facts in an agreed chronology as to what in fact has happened. And it's common ground that the TSJ has declared and continues to maintain the position that Mr. Maduro is the president, and that is not the view that HMG has taken. And so that is the reason, again, that it was found by Mr. Justice Tier and agreed by the Court of Appeal that any decision of the TSJ which takes as its premise the fact that Mr. Maduro is the president has to be ignored under the one voice doctrine. But we say it goes further than that in the context of the reliance sought to be placed by Mr. Vinal on Lord Mance's concerns as expressed in paragraph 65 of Belhage, because Lord Mance is only envisaging a situation, a US-type situation, and the situation which my Lord Legate posited, the concern that if a US president was found by a US Supreme Court to be acting unlawfully, the difficult position and the discomfort of an English court being asked to give effect to those executive acts and disregard the US Supreme Court's decisions. And obviously our primary position as a matter of principle, as I put yesterday, is indeed that is the position. But the discomfort shouldn't exist on the facts of this particular case, because the premise of Lord Mance's concern isn't made out. This is a situation, it's a constitutional crisis. There has been a breakdown of the constitutional framework initiated, at least as perceived by HMG, by Mr. Maduro himself. And your lordships don't have to put that out of your lordship's mind, because that's precisely the reason why HMG chose to recognise Mr. Guaidó and to declare that they don't recognise Mr. Maduro any longer in any capacity. And so Alan Duncan couldn't have been clearer in his letter to Mr. Tugendhat that that was the underlying rationale for the recognition decision, or one of them. There was a humanitarian crisis, and there was Mr. Maduro's systematic assault upon democracy and the rule of law. And so, because we're having this debate in the context of a consideration of recognition, moving then to the closely related act of state question, it's entirely appropriate, we say, for this court to have regard to those considerations. Indeed, they're considerations which Sir James Eadie alluded to yesterday. He pointed out that there are very serious allegations made against this particular court, and one sees that reflected in sanctions imposed by this government. So, Lord, that's all I had to say about the rule of law position and Lord Mance's concerns. Just very briefly on the authorities. Princess Paley, if we could just look at 2859. The argument which prevailed as the alternative ratio, the act of state analysis, was the primary argument of the respondents. And you ought to see that in the first sentence of the summary of the argument, about 6 lines down. The respondents are entitled to the articles in question quite apart from any municipal law of Russia. And then Duke of Brunswick, it was suggested it was only Lord Campbell whose judgment supports a foreign act of state analysis. But Lord Cottenham gave the leading judgment with which the other law lords agreed, and your lordship see on 3341, having set out the much quoted passage that's relied upon in Belhage and other cases, in the second paragraph on 3341, he says, that's the sole question, therefore I avoid the question which doesn't necessarily arise how far a foreign sovereign coming into this country is amenable at all. I don't enter on that question because it doesn't necessarily arise upon the proper disposal of the matter now before us, as I'm of opinion that upon the face of this bill the allegations show that the acts could not have been done and were not done in any private character, but they were done whether right or wrong in the character of the sovereign of a foreign state. So he's looking at the character of the act, and he avoids the question as to the scope of sovereign immunity which the King of Hanover could have relied upon. And obviously then that's made clearer and more explicit by what Lord Campbell says, that it wouldn't have mattered if the Duke of Cambridge himself had been sued. But if we could also just look back at what Lord Sumption said about Duke of Brunswick at 205, he describes that there as being...
Can you give us the electronic page number?
Sorry, my Lord, I'm just trying to find it myself. Thank you, my Lord. And so Lord Sumption says that Duke of Brunswick marked another milestone in the development of this area of the law, not only in England, but in the United States, where it would later serve as the point of departure for adoption of the Foreign Act of State doctrine into their law. And there was an interesting period during the latter part of the 19th century and the early part of the 20th century, whereby there was a back and forth from across both sides of the Atlantic, which were borrowing each other's cases and propositions, and then in developing this Anglo-American doctrine. And, my lords, I won't take you through all of that history, but Duke of Brunswick was first of all cited and endorsed in the US in Hatch and Bez. That's at 5015. Underhill and Hernandez doesn't expressly refer to it, but puts the point in a very similar way. It derives from the same underlying principles. That's at 5369. In Luther and Sager in 1921, the US authorities in Uction and Underhill and Hernandez were cited. That's 2695 and 2704. Princess Paley, following Luther and Sager, then cited also Uction and Underhill, 2866 to 2867. And then another US authority from 1940, which we refer to in our written case at page 2043, called Banco de España, that then cited and endorsed Luther and Sager and Princess Paley. That's 4996. And I haven't spent any time on the US cases because we're dealing with a position under English law, but Mr. Vinell's submission would require your lordships not only to treat the Supreme Court in Belhage as having been wrong to proceed on the basis that Duke of Brunswick was an act of state authority, but also, as I submitted yesterday, Lord Wilberforce in Boots Gas, who saw it as an authority in support of that principle. But also, Mr. Vinell's submission would require your lordship to say that the US cases were wrong to treat it in that way, and that's despite those US cases then having been re-imported into English law in the two Russian Revolution cases. And then just finally on the authorities, Piramal, we referred to Piramal in our written and oral submissions to the Court of Appeal. We cited it in our written case. I took your lordship through it yesterday. Mr. Vinell hasn't once mentioned it. So I need say no more about it other than it's a judgment of Lord Atkin in the Privy Council, which is even clearer as a statement of principle than Princess Paley itself. And it's clearer than Princess Paley because there was no parallel finding in Piramal of a proper foreign law basis for the Executive Act relied upon. His reasoning is only explicable as a pure Executive Act of State case, in that the actions of the Chief of Police in that case, in saying to the respondent, transfer your money to the government of Indore, that was treated as an act of state into which the court wouldn't inquire, as to its validity. And crucially, certainly for our purposes here, the upshot of that reasoning was not to say that the English court could determine nothing. It was to say that the English court would treat that as having been a valid transfer to the government of Indore, thereby defeating the claim based upon the supervening order obtained from the Bombay court for a prejudgment attachment. So it's a classic case of an English court treating as valid the Foreign Sovereign Act, notwithstanding that there was no serious or no attempt to identify what lawful basis under the law of Indore that expropriation of property was based upon. And we don't seek to extend Lord Sumption's analysis. We say Lord Sumption's analysis covers the ground here, both as to the articulation of the general rule and then as to the existence of a fact-sensitive, nuanced public policy exception. And the situation of a foreign ruling wasn't before him, but the logic of his analysis tells the court how he would have responded. My Lord Jones was right to put to Mr. Vinell that what's proposed by him, at least on his secondary case, would be an exception to the Lord Sumption analysis. We say there's no need for any such exception. His analysis covers the ground. There's a general rule, which Sir James yesterday said might be thought to be a rather dry and blunt one. But the general rule simply defines whether the act is caught by the act of state doctrine. And then, if it arises, if a public policy objection is taken, then the court can take into account relevant considerations which may well, in the appropriate case, include the existence or the reasoning of foreign court decisions. But as I submitted yesterday, there's no such argument here. Indeed, Mr. Vinell expressly disclaimed any suggestion that anything that has been done by Mr. Guaidó could conceivably be said to be contrary to English public policy. Sir James touched on the Act of State issue, as he described it, lightly, but he did so in our respectful submission with great insight, not only as to the legal principles in play here and the policy considerations, but also as to the respectful and appropriately deferential concern on the part of HMG that a precedent might be set on unusual facts such as these, which, when applied in a different case, may, as he put it, interfere with the free-flowing lines which exist between sovereign and sovereign. And it's that sovereign-to-sovereign comity which we rely upon as the primary rationale here, and that's clear from the authorities, and this is a stark case in which it's that consideration which should influence your Lordship's analysis. And so we say there are two submissions of Mr. Vinell's.
But that's been pushed to the extent of saying that the considerations of comity not only prevent the courts of this country from inquiring into the legality of the acts of a foreign sovereign within his territory, but also prevent the courts from taking account of judicial decisions of the courts of that territory
yes,
themselves.
We do say that, and the reason, as I've sought to explain in my submissions yesterday, is because the one that necessarily follows from the other. The reason why the court refrains from the first inquiry is because it isn't interested to know what the domestic lawfulness position is, and the only relevance to the rulings of the foreign court are, in this context, as evidence of what the foreign law is. And so they are no different conceptually to an authoritative expert report by the world's leading expert or the country's leading expert. It's evidence of the foreign law, which is being used to demonstrate that the acts sought to be relied upon are unlawful. And if that is off limits, and we say that the authorities identified by Lord Sumption and Pyramid in addition demonstrate that is off limits, then the necessary and logical consequence of that is that an English court puts to one side, at the first stage, in terms of whether or not the Act of State doctrine is engaged, puts to one side those foreign rulings. And if a party dissatisfied with that wants to say, well, no, among other factors, I want to rely upon the fact that this has been ruled unlawful. I want to tell the English court that this is contrary to the rule of law or some overriding public policy consideration, some breach of international law or human rights considerations, and all of that has been endorsed, and all of that is part of the reasoning of the foreign courts, then of course the courts can have regard to what the foreign courts have said about it. I simply say that at the first stage, it's not an exception to the act of state doctrine, the fact that the foreign courts have ruled something unlawful. And here again, we gratefully adopt Sir James's analysis that the public policy exception, which everyone accepts to exist, provides the necessary flexibility to avoid any perception of injustice or contravention of English public policy. And if English public policy isn't being contravened, and Mr. Vinell frankly accepted that it's not here, then there's simply no reason for this court to drive a coach and horses through the Foreign Act of State doctrine and seek to open up these inquiries as to the foreign domestic legality. And Mr. Vinell posited the example of what he described as a bent court happening to reach the correct result. And Mr. Vinell apparently would want to say that the court's corrupt, but nevertheless they analysed the Venezuelan law impeccably. But all of that does is to open up the inquiry, which we say is the impermissible inquiry, into whether the Foreign Sovereign Act was lawful under its own law.
The argument against you, I think, is that the court isn't undertaking any inquiry into the question of foreign law. It's simply giving recognition to a foreign decree.
My Lord, yes, but the upshot of that, the conclusion that leads to, if the English court recognises that, is to produce a judgment which says that the foreign sovereign acts of the recognised president are ineffective. And that's precisely the mischief to which the Foreign Acts of State doctrine is directed. It makes no principled distinction, the fact that the court is arriving at that result through having relied and recognised the decisions of a foreign court.
Your argument depends on identifying the sovereign with the executive, doesn't it? Because we're not talking about acts of the state on the international stage here.
No, my Lord.
We're talking about something that's happened within its territory, typically, confiscation of property or so forth.
My Lord, yes.
And what we're talking about is, say, a confiscation of property by a member of the government, which the court has ruled unlawful.
Yes, my Lord.
And you're saying, nevertheless, we should ignore the court's ruling and treat it as a lawful disposition of property.
Unless it's established that to do so, to treat it as lawful in this country, would contravene English public policy, and that's not suggested.
And that is a reference to the quality of the Act, the public policy. It'd have to be something pretty outrageous. The Act would have to be an outrageous Act.
Yeah, although this is the civil air transport example of the despot plundering state assets.
Yes.
That's in that category.
Yes.
But short of that example, short of egregious acts of kleptocracy, then we say that the starting position should be that an English court just isn't concerned with the identity of a central bank officer. It's not a matter of concern for the central bank. And if there has been some illegality in the appointment, and I come back to the example that could have been a technical illegality, it could have been the blue paper, pink paper example. That's not a matter for the English court to inquire into, because that.
But this approach means if you're dealing with the acts of a rule of law state, which may or may not have a sovereign, and I'm not sure who would be categorised as sovereign in the United States of America. What you're saying is the principle of comity between sovereigns means that the English courts might have to turn a blind eye to a ruling of a rule of law state Supreme Court that an executive had acted unconstitutionally.
We do say that, my Lord. Yes, yes, we do say that.
And on what principle?
Well, it is the higher principle. We say it's the fact that the sovereign to sovereign comity, to which Sir James alluded yesterday, who
is sovereign in the United States of America?
Well, we would submit that the act of the president as the head of state and head of government would be treated in the same way as the act of President Guaidó in this case. But if there is a concern about that, and this was my submission to my Lord Legate yesterday, first and foremost, that should be engaged with, would be engaged with at a diplomatic level. One wouldn't expect the English domestic courts to be the first port of call in resolving the question of how that tension between the acts of a foreign president and his Supreme Court would be dealt with. And if it's a matter of consternation, as a matter of foreign relations, that a foreign president is acting in that way, then the first interception, we would suggest, has to be between the branch of the UK state to whom foreign policy is entrusted, rather than for the English court to undertake an inquiry into whether or not, well, I say not undertake an inquiry. On your Lordship's example, it would be simply to recognise the US Supreme Court decision, but in circumstances where the upshot of doing so, necessarily, is to say, we, the English court, in agreement with the foreign court, are going to tell you, the foreign president, recognised as such, with your sovereign status formally recognised and therefore your ability to act in a sovereign capacity formally recognised, we're going to tell you, the foreign president, that what you have sought to do internally in terms of your political and administrative appointments, what you have sought to do is ineffective. And put in that way, my lords, we would suggest it is obvious why that should be a matter of grave concern at the sovereign-to-sovereign comity level. And so that the instinctive reaction of any court that it might be being asked to give effect to something of doubtful legality, the discomfort about that, we say, has to give way to the higher principle of the sovereign-to-sovereign comity.
Can you help me, please, Mr. Fulton, with this concept of sovereign-to-sovereign comity as the rationale of the second head of active state?
Yes.
At the moment, I have some difficulty in understanding it, and in particular, I don't understand how it differs, if at all, from the rationale that the courts of this jurisdiction should not be sitting in judgment on the legality or validity of the acts of a foreign state.
My lord, it's certainly been expressed in those terms of not sitting in judgment. It's also been expressed in terms of not requiring the foreign sovereign to account for their actions before an English domestic court.
Yes.
And that's the Johnson and Pedler formulation. They shouldn't be required to justify their conduct. And so that's not a sitting in judgment point. That's a question of their acts are entitled to be treated as valid merely by virtue of them being foreign sovereign acts, unless there is a countervailing public policy consideration which persuades the court not to give effect to them, because to do so would contravene English public policy.
But the essence of this is that we should not be questioning the legality or the validity of the acts, because that would be an intrusion into the internal affairs of another state.
Yes. Yes.
Now, does the sovereign-to-sovereign comity notion extend beyond that at all?
Well, we say it encompasses it, and the reason why Mr. Justice Tier didn't get, as it were, bogged down in this concern about the STJ rulings is that he perceived what was happening was, he perceived, in our respectful submission correctly, that the Maduro board was seeking to launch these Venezuelan law challenges to the act of appointment relied upon. The ammunition in support of those attacks was a combination of expert witness evidence from a Venezuelan law expert and the STJ decisions which endorsed those views. And so what as he saw it, this is someone seeking to attack the domestic law validity of foreign sovereign acts.
But the foreign judgment isn't just evidence of foreign law. If it's recognised here, because it's within the jurisdiction of the foreign court and not contrary to public policy or in breach of natural justice, then it's treated by the English court as conclusive of what it decides without any inquiry. It's not just evidence of the foreign law.
Well, my lord, foreign law in this jurisdiction is found as a fact, and the best evidence of that will be the pronouncement of the highest court as to what the content of the foreign law is.
That's if you're proving foreign law as evidence because you want to prove a proposition of foreign law. But if you want to prove the validity of a property transfer, let's say, and there's a judgment of the foreign court on the point, you're not just relying on that judgment as evidence of what the law is, it's binding as to the transfer of property.
As between the parties.
As between the parties.
As between the parties, and that would be a res judicata point. There could be a cause of action estoppel arising out of that. That's not suggested here, my lord. This is not how these STJ decisions are sought to be deployed. Neither the members of the Guaidó board nor Mr. Guaidó personally were party to those judgments. The way in which these...
It's not just res judicata, it's conclusive for what it decides. And they are asking us to recognise those judgments as having decided that the appointment is invalid.
My lord, yes, having decided as a fact of Venezuelan law, having decided as a matter of Venezuelan law, which the court, if it recognises the judgment, will accept as a fact. Not to say that there is some principle of res judicata which prevents us from saying the opposite. And of course, that would be completely unavailable to them, my lords.
No, you can't say the opposite. It is conclusive on the facts and the law, unless you can show, but may be able to, that the court decision shouldn't be recognised here because it was arrived at by a biased court, or whatever the particular argument is, a non-independent tribunal.
Well, certainly our understanding, and this was the reason as we understood it for Mr. Vinal referring to Carl Zeiss in this context, about the evidential value of a foreign court decision, which was on point on the issue in which an English court was interested in. So it's being relied upon as the best evidence, as rather better, obviously, than a expert witness report which might be capable of challenge. The position may well be very different. Well, it would be different. I mean, procedurally, it would be entirely different if it was being said that we, the Guaidó board, cannot assert the validity of the transactions or the appointments which we rely upon because we are bound, as a matter of res judicata, by the decision of a foreign court. And then your lordships would need to consider whether that's the decision of a foreign court to which regard should be had. But that's not the case, and it plainly couldn't be. First of all, we aren't parties, and so it wouldn't operate to bind us in that sense. It's not a judgment in rem, because it's not relating to any property within Venezuela in relation to which an English court could allow the enforcement and recognition of a judgment in rem. And so at most it is evidence, and in an ordinary case, outside the act of state principle, and it would be the best evidence of the content of Venezuelan foreign law. But if, in our scenario, the court doesn't need to know the content of Venezuelan law because the acts have their own status by virtue of their sovereign character, which doesn't depend upon their legality domestically, one sees that from the cases, then the box containing evidence of foreign law, however many decisions are relied upon, can be put to one side. And your lordships shouldn't feel troubled about putting those decisions to one side, in circumstances also where they're issued by the same court, which, as is common ground, takes an entirely different view of the identity of the Venezuelan president. And that's not the reason to disregard them. That's just the reason why your lordships should feel comforted in doing so. The principal reason to disregard them is that the content of Venezuelan law, for your lordships' purposes, isn't relevant. And this is why we come back to the fundamental distinction which we rely upon between the active state doctrine and the operation of an ordinary conflict of laws approach. Because on an ordinary conflict of laws approach, the exercise of the court is to ascertain the content of foreign law and then to apply it. And that's what my Lord Legate has in mind. But it's not the same approach where one's dealing with sovereign acts. And in the case of an executive act which is either admitted or proven to be lawful, then, as is recognised in Dicey, as is recognised by Lord Sumption in Belhage, the ordinary choice of law approach and the application of the active state doctrine produce an indistinguishable result. But in relation to an executive act of disputed validity, the difference is absolutely fundamental, because when applying the active state approach to a sovereign act, the court says, well, it's a sovereign act, so I stop my inquiry there. I don't need to know whether it's domestically lawful or not. Mr. Vinell referred to Lord Mance's approach in Belhage, but Lord Mance's approach in Belhage is that he was prepared to assume, without deciding, that at least in relation to property, a rule existed which would treat as valid executive acts which were unlawful under the foreign law. So that wasn't, the paragraph 65 is not Lord Mance's approach. Paragraph 65 is part of a discussion that it might be said that this is now difficult to reconcile with a more modern conception of sovereignty, but as I've already submitted, that is based upon a premise that the state is subject to the rule of law. And Mr. Vinell also said that the Lordship should adopt the more cautious approach of the majority in Belhage, but the majority in Belhage didn't decide the point that we're interested in here. They left it open precisely because there hadn't been full argument on it. And that's Lord Neuberger at 143. So your Lordships can't follow the approach in Belhage because this arises squarely of a decision now, as Mr. Justice Tier recognised. He said, this point has been left open. It falls to me as a first instance judge to decide, based upon first principles and the authorities such as they are, how to decide it. And he came down firmly in our favour and said that Lord Sumption, in his view, was correct, that the transactions take their effect, not because they're valid under the foreign law, but because they're sovereign acts which the English court won't question. So also, those are my reply points in relation to issue 3 on territoriality. These acts plainly took place in Venezuela. If the BCV had owned assets in every country around the world, then I understand Mr. Vinell's submission to be that the act of appointment should be treated as taking effect in all of those countries. My Lords, if we could just look at Williams and Humbert, 4862, first of all. This was the case of the Spanish expropriation of shares in the Spanish holding company, which in turn owned an English subsidiary, which in turn owned English intellectual property rights. And Lord Justice Fox at C says, in the present case, we're dealing with decrees which were in no way in excess of territorial jurisdiction and which would be recognised in England. And I think that the recognition in England in no way depends on whether the person seeking the recognition is a Spanish state or its nominee or organ. 4865, between C and D, again, Lord Justice Fox, the right to control Williams and Humbert Limited is as much a right attached to the expropriated property as was the right of the Soviet government to give a good title to third parties in Luther and Sega and Princess Pei. It's precisely my Lord Legate's point, as he put it to Mr. Vinell, saying that this is all governed by those early cases. If the act takes place within the foreign territory, and here an expropriation of shares in the Spanish holding company does, then the court gives effect to that, notwithstanding it may feel some of its indirect effects in other countries. And then just rounding this off, 4896, Lord Templeman.
You're going to have to round off quite a lot quite quickly because I've allowed you to carry on because you've been discussing what is the most difficult issue in the case at long last. But you're well over your time already.
My Lord, I apologise. This is my final reference. I'll be 1 more minute. It was just simply Lord Templeman, starting between B and C, down to between D and E. He refers to the illustration, the helpful illustration of railway lines going between London and Paris, and saying that the expropriation of the compulsory acquisition could only extend to the English assets. But nevertheless, if the expropriation was of shares, which owned the whole railway line, that would be effective to change the control over the whole, or change the right of ownership of the whole railway line. So, my Lord, I apologise for running. That was my last reference in a nutshell.
We had a lot of questions for you.
Not the easiest questions, my Lord. So for the reasons that we have given, which are essentially those which Mr. Justice Tier gave last year, the proper result is for your Lordship to reinstate his order.
Thank you very much, Mr. Fulton. Mr. Vinell.
My Lords, I have less than 2 minutes. The Supreme Tribunal of Justice on our case is a court of constitutional competence and its rulings universally binding. That's pleaded at paragraph 23 of our pleading bundle, ref 188. That's the first of 2 points. The second is my learned friend referred to some of the American cases, which we haven't really looked at in any great detail on act of state. In the bundle at 6056 is chapter 9, of Professor Mann's wonderful book, Foreign Affairs in English Courts, and that gives a most illuminating account of the interplay between English and American cases.
Thank you very much, Mr. Vinyl. Well, we have been set a demanding examination paper. It will take us some time to consider all the arguments and to produce our judgment, but we'll let you have it as soon as we can. And we're most grateful to counsel for their assistance.